Hi everyone. Okay, so in this case, our overview will be looking at the Australia Estates case. All right, so this is our case which looks at the Great Peace Shipping test in Obiter. So in this case, a purchaser entered into a contract to buy land for development from Cairns City Council. Now, the contract was subject to a condition that the development be approved by council and that the developer could withdraw if they were not happy with the terms of the development consent. Here, council issued a development consent with conditions. The developer didn't withdraw. Instead, the parties negotiated a new completion date and new conditions to the development consent. So the completion date had gotten pushed back to the 12th of October. And originally, in the original agreement, the completion date was 60 days after the date of signing completion would be. So here it got pushed back a couple of weeks. Then there was further negotiations between the parties and small changes were made to, negotiated decision notice. And at that point, Australia Estates assumed that the completion date had been pushed back again, given that initial 60 days from the time of the date of the contract that operated in the original agreement. So they assumed the completion date had been pushed back again. However, it hadn't been, because the first decision notice, so the first round of negotiations between the parties, that had set that final completion date as of the 12th of October. So what happened then was Australia Estates didn't complete on that 12th of October because they thought the completion date was later. Council then terminated the contract when the completion date passed. Now, the developer argued that both parties were mistaken about the effect of the second amended decision notice, so that negotiated agreement that they thought pushed the completion date back even further. And they argued that that there was a common mistake between the parties, which was a combination of both fact and law. It was ultimately held in this case that at the time of formation of the first decision notice, so that first round of negotiations between the parties, date is the 12th of October, at the time of formation of that agreement, at that point, there was no operative mistake in the agreement to vary the contract. The mistake came later. Okay, so because of that mistake argument didn't hold up here. And in the course of holding that decision, the court stated that a contract is either valid or void ab initio at common law for common mistake. They took the approach consistent with that of Great Peace Shipping, which had overruled Solomon Butcher's approach to common law, common mistake, and equitable common mistake. Okay, so the case here is really most significant for its Obiter discussion of Great Peace Shipping. But just note as well that this is a Queensland case, and also that discussion is Obiter. So the law in Australia still remains unsettled or on common mistake. Lucky for you guys studying this area. All right, moving along. Okay, so in terms of the Obiter on Great Peace Shipping, the judgments essentially indicated some support for the decision in Great Peace Shipping, which itself overruled Solomon Butcher, which we've discussed already. So Justice Atkinson indicated in dicta that Solomon Butcher had had a mixed reception in Australia, and you can see her discussion of McRae and Taylor and Johnson in that judgment as well, which is quite interesting. And she also said that the English Court of Appeal in Great Peace found that there was no jurisdiction for equity to grant rescission for common mistake where a contract was valid and enforceable at common law. Okay. Now, if you look at Justice Atkinson's decision as well, it's significant for the adoption of the 5-part test in Great Peace, which we'll come back to in a moment when we look at our case reading guide questions. President McMurdo did not find it necessary to consider Great Peace, and Gerard agreed with the reasoning of Justice Atkinson, but those two decisions are very short ones, so you'll be able to see them in the textbook. Okay. So in terms of our reading guide questions, so what was the agreement that was vitiated by the mistake? And here it was supposedly that second agreement to vary the contract that set the date for completion on the 12th of October. Okay, so after the first round of negotiations between the party, not the second round, first round. And the alleged mistake was that the decision notice from council constituted final approval as contemplated in that initial contract of sale that set that completion date of 60 days past the date of the contract. Yes, okay, so that was the alleged mistake. What kind of mistake was this? Australia Estates argued that this was a mistake both as to law and to fact, and it was a common mistake that both parties made. But did the court conclude that there had been a mistake? No, they did not. Okay, so Justice Atkinson found that there was no mistake at the time the agreement varying the contract was made, okay, because under statute, the first decision notice was approval until that negotiated decision notice was issued. Likewise, McMurdo found there was no common mistake, and Gerard found there was no mistake by either party on the facts. So in terms of question 5, according to the majority in this case, should Australia recognise an equitable doctrine of common mistake? Okay, and what is the difference between the equitable doctrine and the common law doctrine? Okay, so according to the majority here, you can see at 64, paragraph 64, the statement, there is no equitable jurisdiction to set aside on the ground of common mistake an agreement which is valid and enforceable at common law. So that's a pretty straightforward, clear pronouncement that Australia shouldn't recognise an equitable doctrine of common mistake. Now, in terms of the difference between the two, the common law doctrine offers a much stronger remedy because it renders the contract void, but it's also much more difficult to establish. In terms of the doctrine of equitable mistake, it only renders the contract voidable, but under the Solomon Butcher approach, it's available in a wider range of circumstances. Now, in terms of question 6 then, how convinced are you by Justice Atkinson's reason for following Great Peace Shipping? Is Australia Estates and Cairns a strong authority for arresting the development of an equitable doctrine of mistake based on Taylor and Johnson? Okay, well, as to whether you find it convincing or not, that's really a personal decision. I don't find it particularly convincing at all, although it would be very nice if this area of law was simplified. But in any case, so in terms of the second part of the question, is Australia Estates and Cairns a strong authority? I would say it's not a particularly strong authority at all, but it is definitely something you would need to mention if you've got a problem question on this type of, on a common mistake. In Queensland, it's perhaps strong-ish, perhaps, but in other Australian states and territories, I would say much less so. And part of the reason why it's like not particularly persuasive or not a particularly strong authority is that it's arguable that everything said about mistake in this case is Obiter because no mistake was actually found to exist between the parties. All right, last one. What does Justice Atkinson say is the relevant test for determining if a contract is void for common mistake? Okay, so you can find the test at para 48. And one thing to keep in mind is that this test basically just restates the test for frustration, which is the Cadelpha test. But yeah, so these 5 elements are outlined here. So the 5 elements are there, and you'd need to go through each of those if you've got a question in this area. Yeah, in terms of this test versus the frustration test, this test applies prior to the contract being formed, okay? And in terms of the frustration test, that test applies after the contract has already come into existence. Okay, so just keep that in mind, that timing side of things. All right, so that'll stop us there for Australia Estates.